From the WATE.com Digital Center, answering your legal questions, this is Ask Isaacs. Now, here's Lori Tucker and attorney Greg Isaacs.
Hi, everyone. Good afternoon. We're so glad you're with us today. I'm Lori Tucker, along with our legal analyst, Greg Isaacs, and our special guest, State Representative Sam McKenzie of Knoxville. Thank you so much for being with us.
Thank you for having me.
This is a fiery conversation I think we're going to have, and it echoes what several people have been talking about, sparking protests, public outrage, really, over the sentencing of a former Blount County PE teacher, elementary school level. We're talking about Joseph Dalton, pleading guilty to multiple counts. There's his mugshot right there. Multiple counts of offensive touching of his students. Here's where the outcry comes in. He was sentenced to 6 months of supervised probation. He could have his record expunged. And as of right now, at this moment, he still has his teacher's certificate. So that's where we are right now. So, Greg, why don't we weigh in on really the tough spot, if you will, that the Blount County District Attorney General Ryan Desmond found himself in. I mean, he said, listen, he released a statement saying, I agree the sentence is insufficient, but were his hands tied by what the law says?
Well, ironically, from what we have seen and what we know, that's a public record, Ryan Desmond did everything he could do and probably a little more. And let me explain why. There had been a WATE, at least that's how I got a copy of the employment file for this individual. There had been a history of complaints and investigations that cannot be substantiated. Under Ryan Desmond's predecessor, there were never any charges brought. Here's what happened. This individual got bounced from school to school to school. So instead of addressing what to me appeared as conduct that was indicia of grooming young children, which is horrible in and of itself, he was just kind of swept under the rug and sent somewhere else. So the conduct that could be proven was offensive touching, which is a Class B misdemeanor. There were 5 separate counts. The Attorney General's office opposed judicial diversion. That's a special probation if you're qualified for. You don't have a prior record. At the end of your probation, it's a conditional plea that is then dismissed and subject to expungement. So, trying to go the extra mile and try to find a way to charge this person with criminal conduct, it's really ironically backfired with the Attorney General.
Well, and let's bring Sam McKenzie in now on this, because Desmond said, again, the law is insufficient, and he would support legislation to amend it. But you're like, wait a minute, hold on.
Yeah, there's just always a big push for laws, past laws, more laws. We are a pretty aggressive state as it relates to the laws on the books. I just don't want one case, one thing to automatically change the law. That to me could have some unintended consequences. So I just want to make sure that this is one that that there's a precedent. There's other counties where this has been an insufficient piece of insufficient law, and the judge didn't have any other latitude. But in this case, this sounds like a poor management problem, and I think we need to deal with that. When this was the final issue. So I think there's some upstream things that we can do, but I just really don't like just passing laws saying that we're tougher on crime, when there really probably are other things that could have been put in place.
Let's look at these charges, these misconduct charges, these latest that were in this case. Between September 14th and 21st of 2023, this is in Friendsville. Video footage showed Dalton hugging a 3rd grade girl close to his face, both arms wrapped around her. He also had the girl sway back and forth between his legs. Again at Friendsville, he approached a student and scooped her down to the ground. That's a quote, and stood over her. The girl followed him to his office, and she was seen leaving with candy. Then again in September of 23, now he's at Walland Elementary, so he's been moved. He touched a girl's underarms in a tickling manner and touched her chest. The girl told investigators he got too close to her occasionally and made her feel uncomfortable. it goes on and on. A student violently threw his hand off her shoulder, said, "Enough, quit it." Again, at Walland, video footage showed Dalton pull a girl out of line, put his hands on her wrist, and pull her close to him. So all these things. And here's another one. Dalton bounced and shook his body against the girl and grabbed the girl again. The girl appeared to be upset. He resigned from Blount County Schools in September of that year, 23, and was arrested in January of 24, pleading guilty to 5 charges of assault, again by offensive touching. So that's the max that they could get against this guy after he pleaded guilty to saying, yeah, I was offensive, I shouldn't have done that, I made these girls uncomfortable.
It's a misdemeanor. I mean, you can't put everybody in jail for life in every single case. As Sam knows, we're in the top 5 in the world in incarcerating people in the United States. So here's the thing I think is significant, and one Sam touched on a really good point. This is not a case that was undercharged or that the judge didn't impose a sentence that was severe enough because the facts supported these charges.
And these are not considered a sexual offense.
And judicial diversion was the appropriate sentence to impose based on the factors before the court. Judge Dugan looked at someone with no criminal record, misdemeanors. That was the correct legal call. But what two things are lost, and Sam pointed it out. The first one, this is a mismanagement issue. I've seen school systems all over East Tennessee that shuffle these teachers around that are engaging in grooming behavior. You're trying to seduce, play the long game with these students. But grooming in and of itself is not a separate crime. So that's.
But shouldn't it be?
Well,
and how do you prove it's grooming?
How do you prove it's grooming? But here's the good thing that everyone appears to have lost sight of. This conduct, as it relates to this person, has been stopped before it became criminal. Now think about that. Before it became criminal as a result of these misdemeanor charges, this individual most likely will never teach again. And what you've done, you may not have won in the court of public opinion, but you won in the classroom and you won in the courtroom.
But yet you have these kids who said they were made very uncomfortable, and who knows how that has affected them and their sense of well-being and their sense of self.
And you can draw on your own personal experiences in every school, and whenever you have a teacher that may be too close and too touchy and too whatever. But this one showed a pattern of doing it again and again and again. And, as Sam said, we can't criminalize every single situation. And in response to your question, Lori, is grooming criminal? Well, the first thing that a lawyer would do is that would be overbroad and unconstitutionally vague, because the person that puts their hand on the student's shoulder and says, hey, good job, I'm proud of you. The difference between grooming and being appropriate is the intent of the teacher. And so how do you prove someone's intent? What a reasonable person would do. So now let's talk about what is offensive touching. It is
everything we just listed here.
Absolutely.
Well, it is, but the statute defines offensive touching. There's A misdemeanors, B misdemeanors, C misdemeanors. This is a B. And the conduct is such that a reasonable person would find it offensive or provocative. The leading case on that is a Supreme Court case called State versus Smiley in Tennessee, and the court gave us 3 examples. If you spit in someone's face, it is offensive and provocative. If you kiss somebody without consent, offensive and provocative. Or, and this one was surprising to me, you cut someone's hair without permission.
Why is that surprising?
I don't know. I've got this impression of someone on a playground, and some guy's little kid sees this girl with the longest ponytail in the world and just has at it. But
horrible. So that is considered worse than what this guy.
What worse? This is an example of conduct that courts have upheld as offensive touching. But I would venture to say that if any of these children would have been touched in a sexual way, those parents in Blount County would have beaten the doors down to Ryan Desmond's office, Sheriff Barong's office, and made a complaint of a sexual nature.
It sounds like word of mouth. Parents knew that this guy was making kids uncomfortable.
But
there
you know
just
what?
wasn't enough to prove anything.
Back to Representative McKenzie. So what we have is a management problem by a school system, not an undercharging issue from a prosecutor, or we don't need Sam to fix the law that's not broken.
And I want to talk more about that. What did you want to say before we go to break? Then we'll talk more about mismanagement.
And that's it in a nutshell. There had to be a principal, there had to be an assistant principal, assistant superintendent that really knew what was going on and could have solved this problem, early on because I do think it was progressive, and I'm glad that they caught this in time. But to pass laws for that, I would say we have to be very careful.
All right. We'll have more on this. Stay with us, everyone. We'll be right back. Welcome back, everyone. We have been talking about the former Blount County teacher who pleaded guilty to misdemeanor assault, offensive touching, and we're talking about what that means and what needs to change to protect more kids. And our State Representative Sam McKenzie is with us, and you were talking right before the break about this being a mismanagement type of thing, that people at the top in these schools, where Joseph Dalton, the former teacher we're talking about, was bounced around. Word would get out that kids were being made uncomfortable in his presence and by some of his actions that he pleaded guilty to in 5 cases here. So what can happen? What do you think should happen at the school level, if anything? What kind of changes need to be made?
Well, it's tough, but I always say it all falls to leadership, and I think those leaders need to be held accountable, just like anyone in that situation. I think what should happen is an independent person takes a look at, if a person's been at 3 schools in 5 years or 3 schools in 6 years, that's probably a leading indicator that something may be going wrong. They may just be a bad teacher and don't need to be in front of our students. But what I don't want to do, teaching's tough. It's a tough profession. It doesn't pay well. There's a lot of eyes on you. I don't want to throw out the 99 because we had one bad actor, but I think if we could get to the crux of this particular problem and see what exactly was the behavior that caused this individual to go from school to school, and fix that, not just in Blount County, but in Knox County. Just maybe have someone to take an independent look at those. Now, I'm not saying that we don't need to take a look at our laws. Every year we're passing, several bills each year, and maybe this is one. But I just hate for one case to undo what's probably been, 2 and almost 50 years worth of legal precedents in this great state.
Let's circle back to what Blount County DA General Ryan Desmond said. He released a statement here, and I want to get your reaction to this once again, Sam. None of the videos, but let's go back. The Tennessee criminal laws on sexual battery require contact with intimate parts of a victim. And here's the second part of that. None of the videos or subsequent evidence for these allegations show that the teacher in question had touched the, again, intimate parts of any of the students involved. So therein lies the misdemeanor assault charge.
Yeah, that's tough. It sounded like he touched one of the girls' chest on what you said. I guess that wasn't sufficient enough. But to me, it's I think Greg put it great. It sounds like a grooming kind of activity. Sounds like he is don't know him, but is an individual that doesn't need to be in presence of any children, high school down to kindergarten. But as it relates to that, I can understand that. But if there were 5 charges, could they have run them, in series and not all together? I don't know. I'm not a judge, but the word "what a reasonable person would do," I like that terminology. As Greg said, our prisons are the rolls are swelling with this as we continue to incarcerate our individuals. This may be one that needed some. I don't know, but I just hate to pass a law that's going to have statewide implication because of what I would call mismanagement.
I want to ask you about this. Blount County Commission Chair Jared Anderson, I don't know if you've read his remarks, but he introduced a resolution asking lawmakers to change the law surrounding offensive touching. One of the issues he has with that statute, and I'm reading here, is that it doesn't make a distinction between physical contact with an adult and physical contact with a child. So that terminology, would that change things, Greg?
Again, we have one factual scenario, and we have a law that addresses hundreds and thousands of scenarios. And, misdemeanor offenses, we have 5 levels of felony in Tennessee. Then the next level of criminal offenses are misdemeanors. They are less serious when compared to all those others. But let me echo what Sam said. We have some of the most tough, harsh criminal offenses on the books when you touch a child. Sexual battery, the sex offense registry, all of that, and they carry non-probatable sentences. So, they are very harsh under Tennessee. If you change it, what do you do with the person in a Little League game, the coach that says, you missed the play, son, or a dance teacher that may have picked your daughter up a little too hard, and their intentions was not sexual at all, but were offensive and provocative. Yeah. So, it's easy, and I think Sam should be applauded. If you're trolling for votes, and it's easy to say, that's right, here I am, I'll make this the toughest misdemeanor in the world. Yeah. Well, it's not supposed to be the toughest misdemeanor in the world. If it's a sexual offense, you send them to jail. If it's a misdemeanor, you do what you did. And the other thing lost in this equation, if somebody wants to pass a bill, what about accountability when you see transfer after transfer after transfer? And I don't know the answer to this question.
To your point.
But I would assume it would have to be approved by someone in the administration of a school system. So when you look at his file, which we just did a public records act
Let me
request.
get these. Look at all these papers I have, everyone. Normally I don't
It's
have
a
all these
lot.
notes, but
It's
look at
a
this
lot.
file. This goes back.
Wow.
Take a look here.
Yeah,
2019.
so let's just say this is school administrator Sam McKenzie, and you're handed this. You're going to say, what in the world?
I don't want that person in my building.
Yeah.
That's more than a giant red
I
flag.
don't want this person in my building.
That's right.
So let's kind of leave the DA alone.
Yeah.
If there's no, and think about this. Do we want somebody charged with a criminal offense that we know they didn't do? Because this happened over and over and over. The school system should be accountable.
Right.
Our criminal system, justice system's working just fine, but our educational system is not. So if we want to pass a law or we want to, hold someone to task, now maybe someone did do the right thing. Maybe someone looked at it and was of the opinion that this was conduct that wasn't problematic. But I find that hard to believe. So those are some food for thought. But is this a legislative problem? No. Is this a prosecution problem? No. I think what we have, as Representative McKenzie pointed out, is an accountability on management of a school system, and it happens in counties every single day in the state of Tennessee.
You're all for taking a measured approach,
Absolutely.
weighing each case separately before you come to a conclusion.
Before you come to, there's several scenarios. If someone's having to climb a rope and you're helping that person down, was that inappropriate? There's so much, and I go back to my days of playing football. If you made a good play, a coach would pat you, on the back or wherever, but it was never. It was congratulatory, and what I would hate for us to pass a law that now can be interpreted or misinterpreted. You get someone that's angry at because the child's not on the dance team, and things turn. So again, as Greg said, I think everything was done from a criminal standpoint, but I would hate to not call something a crime that is, but the reverse of that. I would hate to charge someone overcharge someone with something that really doesn't meet that degree.
Here's a question for you, Greg. We thumbed through his, what we see here that came out of his personnel file reflecting a history of complaints that he touched female students inappropriately. As I mentioned, Dalton still has a valid teaching license. Where does it say that that's going to be revoked?
You know, all we can comment on is what's a public record.
Right.
Yeah.
And I would assume that there would have to be some administrative action, and then he would be entitled, as everyone should, to due process, and that would play out. So once again, you know, that system, we don't know, we can't say that it's working or not working. I will say this, now that there have been a plea, but again, the plea is conditional. It's not final unless he does not comply with his terms of probation.
Yeah.
The issue will be, is that sufficient for some administrative agency, entity to do something about the licensure issue? And so that remains to be seen.
Yeah.
Interesting. All right, so time to take a break. All right, we have our digital producer in the wings here, Hope, telling me let's go to break. We're going to go to break. We'll be right back to talk more about this Joseph Dalton case and the fallout right now as far as public outcry is concerned. Stay with us. Welcome back. We're so glad you're with us today, and we would like for you to weigh in. Many of you already have been on social media, on Facebook, on all different kinds of accounts, letting us know how you feel. We've gotten several emails as well about this case from parents who are outraged by hearing this and the fact that this guy is not doing any jail time and is going to be on probation, could have his record cleared if he goes by the standards set by his probationary period, which a lot of people are like, what, 6 months? That's it?
For offensive touching,
Yes.
and because of the convictions for offensive touching, this conduct, which I think there's a argument that it could be legally considered grooming, did not reach the unfortunate, horrible level where a child was touched in a sexual manner.
Was enough done to, in your mind, given everything we've seen here and all of these statements, was enough done on the investigative level to reach the point?
Let's just, and that's hard to say because we don't have everything. When you talk about investigation, to me that connotes that people would have been interviewed, there would have been more work.
They
than
did
just
look at
whatever.
video.
Yeah.
Looked at video. But just one, that was released. Dalton bounced and shook his body against the girl and grabbed the girl again.
That's really disturbing.
If I was a school administrator, I would have to harken back to the show The Apprentice, said,
Exactly.
You're fired.
Exactly.
So, again, I think the good news, if there is good news, the grooming didn't culminate in a child being molested that we know of today.
That's the key
That's the
phrase
key.
as far as we know.
The thing or the lesson learned is, and the other, there are two corollaries. One, there is apparently a mismanagement issue because if I was the lawyer advising a school board and they said we had a teacher that bounced and shook his body against a little girl and grabbed her again, I'd say out, gone. But the other thing is, again, we have heightened parents' attention to behavior at schools and safe touching, inappropriate touching. So think about the general deterrence that has been achieved, and that's what Desmond wanted to do. I can't charge this guy sexually, so I want to load him up with misdemeanors, and he did. Yeah. But the problem is, he thought he would create attention, but he created a tsunami. And the problem with the tsunami is a lot of things get run over in a tsunami.
And to that point, what I'm hoping is that when the parents dig in, they dig in all the way. That they look at the case, and even if they wanted jail time or him to go away forever, they continue to understand what the process is and to push their school board to say, what's our accountability at the local level? What's our classroom accountability? What's the building level administrator? Just engage in the whole process. Not just want Joseph Dalton head on the stick. That's fine, but let's continue the process to make sure that this doesn't happen again.
Well, and as you alluded to, it's a lesson for parents to talk to their kids, talk about what is safe touching, what isn't, because a lot of times, and I'm not condemning this guy, he did plead guilty to these charges, of offensive touching, but a lot of times in other cases, as we well know, these perpetrators will go after the most vulnerable
That's
kids.
right.
And so these are the kids that need to know these things, and that's what is so concerning as well. We don't know that's the case here.
Right.
But
We don't know it's the case, but again, it has hopefully created general deterrence. It has made parents have dialogue with their children. It has caused
Yes.
administrators to take a closer look. And if this causes this school system or other school systems to be more vigilant, and when they see indicia of grooming, to react, this will have accomplished what the DA's office wanted to accomplish. Putting one person's head on a stick or a pike isn't going to do it. Fixing the problem is what's going to help save children, because everybody, and what's ironic, the DA's office, the school administrators, the parents all are really in agreement, and we don't want our children being touched inappropriately at school.
Right.
So when they get off that bus, they are entrusting their child to that school system.
That's right.
And that school system needs to be vigilant and protect.
One thing I want to ask you before we run out of time, and this has been a really good conversation, so we want to keep it going as long as we can, but what do you plan to do in terms of conversations with your fellow lawmakers, or meeting with the DA? What are you thinking right now?
Well, I know that Representative Stinnett represents that area. He and I are good friends from a legislative standpoint.
He's meeting with the DA.
Yes, so I want to encourage him to bring meaningful legislation if he feels the need. We all get an opportunity to present 10 bills each year, and if he wants to use that's fine. But what I want it to hopefully be is something that is going to get to the root of a problem where we have precedent that this is a shortcoming, not just in Blount County, not just in one other county, but it's something that's not going to hurt our school systems and our teachers system-wide. So whatever that looks like, I want to support. So I really just want to keep listening, as more and more comes out on this case. I do think we can learn a lot from these actions that this gentleman took, and become a better state because of it. But again, I'll go back and say, I just don't want to. We got a reaction, people are upset, so let's just pass a law. As you said earlier, that's kind of the easy route out. The more difficult route is to be measured, to understand that our tentacles go from Mountain City to Memphis, and that we have to really be careful how we think about these changes to our laws.
And Lord, one thing again, if this acts as this situation a general deterrent against children being sexually touched, molested at school, is great. But what I hope does not happen is that John or Jane Doe, Attorney General in a different county, is faced with a decision, and someone comes in his office and says, this is not conduct that is sexual, it's just provocative and offensive touching. And then he's, I hope he doesn't scratch his head and say, well, heck, if I charge this guy with that, I'm going to be in the middle of a protest and a parade. So just realize, the pendulum swings both ways. So, you don't want our elected officials to be afraid to act, but on the other hand, you want to make sure that there is accountability systematically.
And weighing all sides.
Absolutely.
When you have a parent whose child comes home and says, Mr. Dalton touched me and made me feel terrible, you're going to want somebody's head on a stick.
That's right.
And absolutely, and God bless them, and those parents have the right, and they should protest. And you can protest for offensive touching as much as you can protest for anything else.
That's right.
And that's their God-given right, and I'm glad to see them doing it.
Yep.
So to me, this is a win-win-win. But let's not deter other prosecutors from taking steps to prosecute people that are touching our children inappropriately. Let's get the groomers before they become sexual predators, and let's get the Sam McKenzies of the world to create the laws that we need to do it all.
That's right.
You know, and speaking of the Sam McKenzies of the world, our special guest, we want to thank you so much for being with us. We want to give you the final word.
Well, thank you all for having me, and thank you for this conversation, because it's tough. We passed some really, some controversial, most are easy, but the ones that you have to dig in and really fully understand the implications, not just today, but 5 or 6 or 10 or 50 years down the line, you have to really think that. So thank you all for this conversation today.
Thank you for all you do and for coming in.
Thank you.
Thanks, Sam.
All right.
Let's talk more at 5:30.
Let's do it.
Okay. Thanks again for joining us.